So good afternoon, everyone. Welcome back. My name is Sean Conway, and I want to welcome all of you. Some of you may have attended prior sessions, and others of you may be attending for the first time. But in either case, we want to welcome all of you to today's webinar version of the 2020 virtual NBCOT Occupational Therapy State Regulatory Leadership Forum. We are delighted to have all of you here, and we hope that this will be a real value-added presentation for all of you in your respective roles as occupational therapy state regulators. So again, welcome to all of you. For those of you that have attended some of the prior sessions, you know that we're asking each of you to enter your names and your email addresses into the question and answer field. And the reason that we're doing that is so that we can subsequently share the electronic versions of your certificates of attendance. And please know that, that information will not be shared in any way outside of this presentation. It is only for logistics purposes. So in terms of today's presentation, we are really excited to be able to share this information with you about the AOTA and NBCOT Joint Occupational Therapy Licensure Compact Initiative. We're hoping that for most of you, if not all of you, that's at least sounds very familiar. And we're going to talk with you a lot more about this initiative and share with you some of the experiences that we've been working on to date. As I mentioned, my name is Sean Conway, and I'm with the National Board for Certification in Occupational Therapy. And I'd like to introduce to you Chuck Wilmarth, who is the Vice President of Health Policy and State Affairs with the American Occupational Therapy Association. So Chuck, we are delighted to have you with us today. And I'm wondering if you'd like to say a few words and to introduce Dan Logston as well.
Thanks, Sean, and thanks everyone for dialing in for this webinar today. We're really excited about this initiative. We're very excited about our collaboration with NBCOT. My position with AOTA is Vice President of Health Policy and State Affairs with AOTA, and I've worked with state associations and state regulatory boards for many years on state policy issues, including, getting the profession licensed in all 50 states, DC and Puerto Rico. And I say, just as the balloons came from the ceiling and we celebrated getting licensed in all those states, the next challenge was put before us, which was to work on a licensure compact for occupational therapy. So we're going to talk to you about that today. And I want to introduce Dan Logston with the Council of State Governments. And his shop works on these compacts. And Dan, introduce yourself.
Hi, good afternoon, everyone. My name's Dan Logston. I'm the director of the National Center for Interstate Compacts at the Council of State Governments. CSG is a membership organization for states. Every state's a member, every state pays dues. We were founded in 1933 at the University of Chicago and have worked on interstate agreements, interstate compacts, chiefly among them since our founding.
Great. Thanks, Dan. And before we get into the nuts and bolts of licensure compacts, Sean and I wanted to give you a little bit of history on NBCOT's as well as AOTA's research into compacts and what led up to this initiative. Sean? You're muted, Sean.
Thank you so much, Chuck. I appreciate that. In terms of the NBCOT's history on licensure portability, you can see on the screen that some time ago, dating all the way back to 2000, NBCOT had started to introduce these topics at its annual state regulatory conference, now referred to as the State Regulatory Leadership Forum. In those days, the approach of telehealth was literally brand new, and there was a woman who was the director of the telehealth department with the Health and Human Services Agency. And she had come several years to actually start to share with the occupational therapy state regulatory community some information about what telehealth was and how this was beginning to evolve. And then over subsequent years, you can see on the screen that there were a number of other different presentations that really sort of then broadened well beyond telehealth and really started talking about and looking at, the whole notion of portability and being able to transport and move across state lines. One of the other things, in addition to the state regulatory conference that NBCOT did in terms of, again, helping to educate the occupational therapy regulatory community, was to share this information on some of our state visits. As many of you know, we make routine visits to state regulatory boards in an effort to keep the boards informed of certification and regulatory policy trends and issues. And so this was another occasion or opportunity for sharing that kind of information. And then in addition to meeting with regulatory boards, we would also share that information at various professional conferences. So in a nutshell, really working hard to, try to keep the community informed of trends and patterns as they were starting to emerge and evolve. And then more importantly, talking with folks about what that means, in this case, directly to occupational therapy. So with that said, Chuck, I think you wanted to give some background in terms of AOTA's initiatives around licensure portability.
Great, and thanks for that historical perspective on NBCOT's efforts. And it's interesting, I think it was at the 2014 state regulatory meeting, there was a panel discussion talking about portability and I think telehealth. And the question to me as the person from AOTA was, what is AOTA doing about this? And I said, well, at the time, it wasn't a priority, but if a member wanted to bring forward the concern to our policymaking body, the Representative Assembly, they could do that. And that person did exactly that. And a motion was brought forward to our policymaking body, creating an ad hoc committee to study the topic. And so that group worked for probably, just about a year, exploring portability and the implications. Now, here we are moving forward with the licensure compact, but there are other ways to facilitate licensure portability, to facilitate mobility. You could have reciprocity, you could have uniform state laws, you could have expedited licensure. So that ad hoc committee, comprised of the people in the profession, looked at the different models that have been implemented by the Nurse Licensure Compact. We spoke with physical therapists at the Federation for State Boards of Physical Therapy. We looked at the Medical Compact, and we also looked at efforts to expedite licensure. And at the end of all of that, the committee came forward with recommendations, and one was for AOTA to pursue expedited licensure and reciprocity. And the other was to pursue portability through a compact. And ultimately, this is kind of into the weeds, but the policymaking body, the Representative Assembly, rejected the idea that we should go for reciprocity and expedited licensure, and decided to endorse the idea of a compact as having the best legal mechanism to institute licensure portability. So that took a while to process. And as it mentioned on the screen here, the policy was adopted in 2016. Now, at the time, there were concerns about the resources necessary to work on the licensure compact, and there were some questions about, was it necessary? So we commissioned a study looking at the future of payment for telehealth under Medicare in particular, but also looking at the broader landscape in terms of reimbursement for services. Telehealth is definitely a driver for the licensure compact, but we also wanted to understand, when paying free. Long story short, it was decided that we couldn't wait, that telehealth was emerging, but also members wanted to move about the country. They wanted to be able to get licensed quickly in one state and then another state. So this was included in the AOTA strategic plan in 2018, and we received funding to move forward with hiring the Council of State Governments shortly thereafter. And then we'll pick up the history a little bit later on. I think at this point it might go to Dan next.
Yeah. Okay. Thanks. Thanks, Chuck. And again, welcome everyone. Again, I'm Dan Loxton with the Council of State Governments. I run the Compact Center there. Happy to work with this profession. Another thing that I do at the Council of State Governments is I administer 2 large Department of Labor grant projects where we look at occupational licensure in the states. And I can tell you from that experience, your profession is at the top of the list as far as they've done a great job over the years syncing up requirements out in the states. Compacts thrive on uniformity. These licensure compacts certainly thrive on uniformity, and it was much easier to find that uniformity for this profession than other professions that we've looked at. So kudos to you. So let's talk about interstate compacts. Many of you have probably never heard of an interstate compact, but you probably have an example of an interstate compact either on you or somewhere near you. Your driver's license. So that wasn't the federal government passing a law telling everyone, all the states, that they had to let someone that was licensed in one state drive in another state. That's the states coming together to find an adaptive solution that they could make work for them. That wasn't a one-size-fits-all solution, and that would take in the variations of how states license folks. So whereas, maybe one state doesn't allow a right turn on red, another one does, states are able to work that out, not have to have some sort of overarching federal solution. So they're just contracts between and among states. They are powerful adaptive tools for states. Not every issue deserves an interstate compact. It's sort of like killing a hammer with a fly, or a fly with a hammer sometimes. But they are something that states need in their toolkit, and that they use readily, especially beginning in the 20th century, which I'll get into in a few minutes. And initially, colonies in the states use them to work out their boundaries. There's a compacts clause in the Articles of Confederation. There's a compacts clause in the U.S. Constitution, certainly. But again, these are just ways for states to come together, adopt agreements that are state-driven. They allow states to cooperatively collaborate on either bilateral issues. You only need 2 partners, 2 states to create an interstate compact, regional issues, or national issues. Currently, there are 5 national interstate compacts, 6 if you count the Insurance Product Regulation Compact, which has 45 member states. They're also a terrific way for states to maintain their sovereignty in our federalist system. So, as I said, initially states used them to work out their boundaries and access to waterways, but in the 20th century, in 1922, the New York, New Jersey Port Authority Commission was established via an interstate compact. So that's almost 100 years old. Now it's a $9 billion agency with thousands of employees. And frankly, the reason that New York and New Jersey wanted to work out a contract among them between each other is they didn't trust each other, and they wanted to have a remedy to go to federal court to hold each other accountable for the provisions of the agreement. About 10 years later, in the early 30s, you saw the adoption of the Colorado River Compact. 7 western states joined together to figure out, how much water can we pull out of the Colorado River, how much waste can we put into the Colorado River. And from that point on, throughout the 20th century, you saw states use these mechanisms for a variety of issues around transportation, around how to ship low-level nuclear waste, children in foster care, adult offenders, juvenile offenders, probationers, and parolees. And in the last part of the 20th century, in the last decade of the 20th century, you saw the first work toward an occupational licensure compact, which we'll get into in a few minutes. But every state is a member of at least 24-ish interstate compacts. So I'll have legislators sometimes, especially new legislators, that'll say, I like this idea, but I just don't think my state would ever join one. And I always tell them, I've got good news. Your state has already joined probably, at least 24 of these mechanisms. So here's just a quick heat map about, where most of these compacts are adopted. Again, every state joins interstate compacts. Every state participates in the creation of interstate compacts. It's incumbent upon CSG to continually advise new legislators and new state policymakers about the relevance of these to their state, because again, they belong to so many. And the benefits, so we've talked some about the flexibility and the autonomy that a compact gives them as compared to national policy. So it's not really a criticism of Congress. They can't take in the vagaries of state policy in the various states when they're writing laws. They have to write a statute and tell the states to comply. But with an interstate compact, states do get a bit more flexibility. They, again, allow for economies of scale. There's dispute resolution among these. So I mentioned New York and New Jersey wanting a federal court to kind of arbitrate issues between them, but all the modern compacts have built-in dispute resolution mechanisms. These licensure compacts are the same way to try to avoid having to go to the courts, and states can generally work out these issues among themselves. They do allow for state and federal partnerships. A lot of the environmental compacts have a federal partner. A good friend of mine is general counsel for the Columbia River Gorge Compact. The feds sit on that compact. And then again, it allows states to collaboratively come together around issues and work together to solve them. So it really creates a forum for states. These compacts do for states to demonstrate their best attributes and work together to address policy issues. And try to there are certain things under our federalist system that are reserved to the states. Occupational licensure is certainly one of those. So the states, like as someone who works for a state government association, we love the federal government, but we don't want them involved in everything, especially things that the Constitution reserves explicitly to us. And then for occupational licensure compacts, so I mentioned the nursing compact. They started looking at that in the late 90s. The National Council of the Board of State Boards of Nursing wanted to create a mechanism whereby I could take my license in good standing from my home state, my state that my primary state of residence as a nurse, and practice in other states. So in 2002, they stood up the Nurse Licensure Compact, the original version of it. And it had a few deficiencies. It required everyone to get the multi-state compact license. People didn't really like that. It didn't have an interstate commission, which turned out to be a real deficiency. It didn't require strong provisions around an FBI fingerprint-based criminal background check. And even with all that, it still got 25 states. So it's morphed into the new Nurse Licensure Compact, or the Enhanced Nurse Licensure Compact. There's now 6 other licensure compacts that exist. OT is the 7th, and then we're working on the compact for counseling to be the 8th. And the benefits are, again, agreement on uniform licensure requirements. I talked about your profession. That was especially easy to find. Data system. So again, what the first iteration of the nursing compact found was this data system was going to be a crucial function. Disciplinary action and dispute resolution. I've talked to a lot of administrators of state boards who, have tried to get states to cooperate in a profession without an interstate compact, and then in a profession with an interstate compact, and they really talk about the ease that a compact brings to that. State boards, I know, typically try to help their fellow state boards with investigations, but a compact embeds that in statute. Fingerprint-based background check, so we do sort of raise the level for who can participate, and there is, this compact. A lot of licensure compacts look at criminal record, and then your track record with the board if you have any encumbrances or restrictions. Typically, this compact, the PT compact and the compact for speech pathologists and audiologists, have a 2-year look back. It does centralize processes. It leaves, though, I think the thing that states respond to is we're just facilitating interstate practice and extending the reach of state boards. It leaves the state licensure process in place, and it leaves states' ability to regulate the profession through the scope of practice in place. So, and then looking at why we have state healthcare licensure reciprocity. Not all professions should probably have an interstate compact, and we certainly don't think that they should. What we've heard from legislators is that they think health and allied health probably should, maybe teachers, but they're skeptical about the rest. And as you'll see on the next slide, all of our work has been in the sphere of health and allied health. So certainly we're a more mobile society. Certainly around telehealth, you're seeing a lot of technological advances that are driving that. Access to care is a huge issue. We work very closely with the Department of Defense. They're interested in all these licensure compacts as a means to help military families, but they're particularly interested in the mental health compacts because they see it as an access to care remedy for veterans. You've got and we mentioned there at the end the support of spouses and relocating service members. So all these compacts have provisions. All the licensure compacts have provisions to assist military families, allow a spouse easier access to the marketplace, so that they don't have to struggle to reestablish themselves in their new state where the change of station has taken place. And then we mentioned the original nurse licensure compact. So here's a list of the compacts that we've been talking about. It got to 25 states in 2011-12. The nursing boards came back together and decided they were going to rewrite it. And now the Enhanced Nurse Licensure Compact, which is just now the Nurse Licensure Compact, has 34 states. The EMS Licensure Compact has 20 states. The Medical Licensure Compact, it now actually has 30 states. Louisiana just enacted it last week, so need to update this slide. Physical Therapy Compact has 28 states. SIPAC 15. The ASLPIC, so the Speech Pathologist and Audiologist Compact, it actually now has 6 states. It passed along with the Medical Compact in Louisiana. The APRN Compact, that's been mothballed for the time being as they work out some issues with the American Medical Association. And then the OT Compact, which we're talking about today, and then the Counseling Compact should be ready in January or February of 2021. So that's just sort of a brief overview of interstate compacts. If you'd like more information about that, you can obviously talk with the folks at NBCOT and get a hold of us, and we'd be happy to provide more information to you. You can also check out csg.org, our website, for more information about compacts. So now we'll go into talking about, the occupational therapy licensure compact. So got a few slides here. Just want to go over the compact with you. I'll encourage Chuck and Sean to jump in as they'd like. They have been working with me we've been a little over a year on this project. I think it was exactly 1 year ago we first met in Washington, D.C. to begin work on this document. So would appreciate if they want to jump in with any comments, would welcome those. So the big picture about this licensure compact, it's for licensed OTs and OTAs who obtain that legal privilege to practice, that compact privilege from the Interstate Compact Commission. Again, states retain their authority to regulate the profession. This compact states explicitly that while someone is in a remote state, in another compact member state practicing, they are under that state's regulatory authority. Your Practice Act doesn't travel with you. You have to adhere to the rules of the road in the state in which you're practicing. Chuck and Sean talked about the joint initiative, and this is going to be a multi-year initiative. Interstate compacts, I believe, are terrific. I think I think they're the gold standard as a means of facilitating interstate practice, but they are certainly not easy. It does take a few years to get them stood up, but I think the safeguards that they provide to the public, the safeguards they provide to state sovereignty, frankly, which is a big concern for legislators, and the ability that they give a practitioner to sort of seamlessly practice with that compact privilege, it's worth it. And then this compact has a 10-state requirement for being stood up. So that means that 10 states have to enact the compact in order for it to be duly authorized to do business. This compact, though, like all the licensure compacts, has the ambition to be a 50-state compact, a national compact. All right, and then I want to talk to you about the development of this. So we've been working nonstop since last October. When CSG convenes a compact project, we've developed a template over the years to create these compacts, and the first thing we do is create an advisory group. So we formed the advisory group. It met for the first time in person in October of 2019. We worked remotely via phone. And that was before Zoom took over everyone's lives, so we just did conference calls. But we were working through February of 2020 to create a set of recommendations that then we handed off to the project drafting team, and they met for the first time in late February of 2020 to begin work on drafting the compact. So we worked remotely in March through May. Took the document back to the advisory group in May, got their blessing, if you will, to go out to stakeholder review. We did stakeholder review throughout June, July, and the first part of August of this year. We took all the feedback and the comments that we received during that stakeholder review portion of the development, cataloged it, compiled it, presented it to the drafting team. They spent the latter part of August, the first part of September going through it, discussing it, made a few changes to the compact. I'd say it's still about 85% the same as what went out for stakeholder review. If they had changed it dramatically, I think that would have, triggered another round of stakeholder review, but 10 to 15% is all that got changed. In late September, we went back to the advisory group. They received the stakeholder review documents, the comments and the suggested changes. They reviewed those. They made a few tweaks. And in October of this year, the advisory group gave their approval to the effort, and the compact became locked at that point, and we're ready to go to the states for enactment. Also, the NBCOT Board of Directors endorsed the compact this month, as well as the AOTA Board of Directors as well.
Hey, Dan, I had just a couple of questions here. Maybe you can address. Can you talk about who was on the advisory committee? I mean, not specific people, but what their backgrounds are and what the difference was between the advisory group and the drafting team.
Right. So for the advisory group, CSG typically, and let me just go ahead and jump to this next slide here. So this is our development process for creating these interstate compacts. So the advisory group is a larger group, about 20 people. It's made up of state policymakers, folks from the boards, executive directors, board council, board members. We also had practitioners around the table, educators. Sean and Chuck were both on the advisory group, and then CSG staff. So we're not really looking at where folks are from. We're not trying to plan ahead to see, well, we definitely want to get someone from Texas on there. We definitely want to get someone from New York on there. We're really just trying to get folks from the profession that are knowledgeable, that can help us create a solid set of recommendations to hand off to the drafting team. And then the drafting team is a much smaller group of folks. We wanted a couple of extra attorneys in the room. We had a practitioner, we had former board member, we had a current board member, both OT and OTA. And so, it's a smaller, more focused group that really gets into the weeds of how do we effectuate, how do we bring out in the document what the recommendations were from the advisory group.
Thanks.
So again, we're in the middle of phase 2 now. These compact projects never really leave phase 2. Until they get to their threshold number of states to be a national compact. But again, we finished with phase 1. This is a tried and true system that we've put together over the years, over the decades that we've been working on them. It's an open, transparent process. It has to be, because once these documents reach the legislature, they can't be changed substantively. And so it's important for us to get a lot of feedback before we ever finalize the document. So that's why we do such a robust stakeholder review process. Okay, so what is this thing that you've been talking about? It's an interstate agreement, so it's a contract that states will enter into with each other. Its purpose is to facilitate practice across state lines via compact privilege, just like the PT compact, just like the ASLP compact. It is similar in form and function, as we say here, to nursing, psychology, physical therapy, EMS personnel, audiologists, and speech language pathologists. And the reason that is, and I'll get to that more thoroughly in a second, was, this is what's called a mutual recognition type compact, so that states are agreeing to mutually recognize your license in good standing in your home state and allow you to get a compact privilege to practice in their state based on that. The medical compact is an expedited licensure model compact, where you're actually getting licensed in every state. That's a good model for physicians. It is a remarkably expensive model, and it's just not sustainable for other professions. It addresses the increased demand to provide and receive occupational therapy services. And then, as we mentioned, once the 10th member state enacts it, it's ready to be stood up and the Compact Commission can convene. So, again, mutual recognition model. So your home state license essentially punches your ticket to participate in the Compact, as long as it's in good standing. As long as you have not had any restrictions in the previous 2 years, as long as you complete a jurisprudence requirement that the state may have, and that you pass an FBI fingerprint-based criminal background check, those are the requirements for the Compact. So it allows OTs and OTAs. So like the PT Compact, it allows for assistants to participate. The Speech Pathology and Audiology Compact is only for those two professions. We had a lot of discussions about including assistants, but again, it gets back to uniformity driving this. If I believe there are 50 different ways to regulate speech pathologists, audiology assistants out in the states, because they all do it differently, and there just wasn't anything for us to grab onto and allow assistants to participate. But this Compact, again, because this profession's done such a good job of syncing up its regulations out in the state, we were able to include assistants. So it does establish an interstate commission. All modern compacts have this interstate commission. That was a failure of the original nurse licensure compact, that it didn't have that interstate forum for licensing boards to cooperate and collaborate around. And again, all modern licensure compacts have those, and all modern compacts have those. It's funny, sometimes I'll talk with legislators and they'll have a problem with the interstate commission. And again, I don't know if my state would ever do this, and I've got good news for them. There are 5 national compacts that every state is a member of, and they all have an interstate commission. So they already belong to a compact with an interstate commission. And then again, we mentioned the data system. So it creates that robust data system that all these licensure compacts rely on, both for verification of licensure and then disciplinary sanction. And then this compact and the upcoming counseling compact creates a pathway to licensure based on that compact privilege when practitioners change their state of residence between compact member states. So if you leave one compact member state and establish residence in another compact member states, the states will come together and create a pathway to licensure for you other than the initial licensure process. Oops, sorry, let me go back here. And then, so, we mentioned that these compacts really have a dual purpose, right? So yes, they're primarily for facilitating interstate practice, but they're also there to protect the public and expand the reach of regulatory boards to deal with folks that may not be living in their state, but that they need to regulate because they're practicing in their state. So we mentioned that higher bar, right? So you must pass an FBI fingerprint-based criminal background check. You must have an unrestricted license for the previous 2 years. This compact, different from the speech compact or the PT compact or even the counseling compact we're working on now, the drafting team and the advisory group wanted to define what that 2 years meant. So that's something different for this one that you don't really see in the other ones. The other ones sort of leave that to the Interstate Commission to determine, but this compact project team wanted to define that as being 2 years from the time that you've met all your requirements from that restriction. And then reliance on the home state and the primary state of residence, that means reliable tracking of practitioners. Well, we hear sometimes from groups that say, well, we think that's a little bit too restrictive, this reliance on a home state, and you ought to be able to get a compact license if you can get licensed in another state. And that sounds good, and in most instances it would probably be okay, but it really diminishes the public protection aspect of this, because let's pretend I live in Kentucky. Kentucky doesn't join this compact, but Ohio does. So I go to Ohio and I get a license, and then I use it to practice in South Carolina, and I run afoul of the board in South Carolina. So they're trying to serve me with documents, maybe even serve me with a subpoena. They look in the compact database. I got my license in Ohio. That's what I use to enter the compact. They come to Ohio and say, hey, we need some help serving this subpoena. And Ohio's just going to refer them to Kentucky because that's where I live. So if you had a compact member state that was working on that with you, it embeds in the statute the requirements to help your other compact member states meet out that discipline, serve those subpoenas, do those types of things, give priority to that investigation. Now South Carolina is just going to have to go to Kentucky and hope they're willing to help them. And certainly they'd probably try to help them. But with compact member states, again, it's a requirement. They've all agreed to take on these obligations. And then state licensing boards. So again, they retain control over the scope. They retain control over the initial licensure process. They get access to that centralized compact data system, and then they appoint the delegates to the compact commission. So this isn't something that flows up through the governor's office or that the legislature does. That compact commission is really an extension of the state regulatory boards. And for this compact, they have to be an OT or an OTA, a public member of the board, or a board administrator. Okay, and then so if I'm a practitioner, how do I access this compact privilege? So we've talked a lot about the home state license. So also have to have a social security number or a national practitioner identification number. Have no encumbrances. We've talked about that. I have to notify the commission that I'm seeking this compact privilege. So all that would happen on the compact database. We've got compact website. We've got a slide coming up about that I'm going to ask Chuck to speak to. And then, if I want to get access to the compact, I also have the obligation that, if I have a single state license in a non-compact member state, if I run afoul of that board, I have an obligation to notify the commission within 30 days that I've had that action taken against me. So again, we're even capturing for the practitioners incidents that don't happen in compact member states. Okay. So another feature of all these licensure compacts, or at least the modern licensure compacts with nursing, the mutual recognition compacts, is that your home state continuing ed requirements apply. So unless it's related to scope of practice, you don't have to complete these continuing ed requirements in remote states. The compact privilege renews at the same time as the home state license, so trying to give practitioners a little more reliability about what they have to keep up with. And again, practitioners must adhere to the laws and regs of the compact member state. So you won't have a defense before the board if you're in a remote state engaging in a practice that they don't allow, but your home state does. Even if you have a competency in it, if that state doesn't allow it in its practice act, you can't engage in it while you're in that state. And then again, this compact, like all the compacts, this one does it in the compact language, gives a real benefit to military spouses by allowing them to designate a home state during dependency of their service in the military so that they never have to leave the compact and can stay in the marketplace. And then Chuck, here's the slide that we've talked about before. This is from the PT compact. This is how the PT compact works. I think for the OT compact project team, this is how we envision at some point in the future, once we get this thing up and going, how it would work to distribute those privileges. Chuck, I didn't know if you or Sean wanted to say something about this slide as well.
Yeah, I'd like to speak to the slide, and then there's also a question that's popped up in the Q&A that I think is relevant. So, this is, from the licensee's perspective, why do I want to participate in the compact? I could easily apply for licensure in multiple states. Well, the idea here is that there's a central place, and we've reserved the domain otcompact.org, where there's a website where you go and you apply for a compact privilege. Now, if you need to take a jurisprudence test, you have to do that. You're going to have to, of course, pay a fee. But once you get all the information in there, and of course, you also can't have any encumbrances on your license. But once that happens and you buy a compact privilege, you will have the legal authority to practice in whatever states you signed up with right then and there. So, if you want to do this currently, you have to fill out applications and submit documents to individual states, pay fees, and get licenses back. This is going to really streamline the process of being able to practice in multiple states. Now, there's a question in the chat box, and I'm just going to read it.
Sure.
The compact is initiated by the professional organization, but every state has its own licensure criteria. Does reconciliation between states take place? I.e., a state may not want to enter a compact if it thinks another state's standards are not comparable. Please clarify. And the simple answer to that is no. And I think Dan would say it this way: a license tick is your A license punches your ticket to enter the compact. I mean, looking across all of the states, the licensure requirements are pretty much the same. The core licensure requirements are identical. You have to graduate from an accredited OT or OTA school, you have to complete field work, and you have to pass the NBCOT certification exam. Now, there are some other, small requirements around, I don't know, maybe one state requires a letter of reference, or maybe there's some other requirement. And this does recognize the jurisprudence requirements, but all those other requirements are not relevant here. That once your state enacts legislation, it passes the House, the Senate, the governor signs into law, that is a contract between the two states, or between the states that sign up, that says if somebody presents themselves with a license in another state, we agree that they're able to get a compact privilege. So those minor differences in state law don't matter. And the way that this works is the compact supersedes conflicting state law. So those minor differences are just not relevant or important. And that's also where, if you are licensed in a home state and you have multiple compact privileges, you only need to worry about CE requirements in your own state, not every other state. Currently, if you're licensed in a home state and you're licensed in 10 other remote states, you need an Excel spreadsheet to track all those different state requirements. This brings uniformity to the process. So I guess Dan for his thoughts on that question, and then Sean, if you could weigh in too, because I think it's a very important point.
Sean, why don't you go ahead?
You.
Yeah, sure, Chuck. I mean, I agree in terms of the portability that this will provide. And I think the last point that you made in terms of the compact superseding state law is essential to this question, because it clarifies from a legal perspective, what entity is responsible for addressing those kinds of issues if and when they do come up.
Yeah, I would just say that I can't speak to this profession in the same way that Sean and Chuck can, but in viewing the requirements out in the states, OTAs were a component of one of our Department of Labor grants, and it was remarkable how much uniformity existed out in the state. So look, I know how states license a profession is important to them, but there's a lot of trust with these compacts, and for this profession, I think there's a good basis to be faithful about that trust, because this isn't some professions where there's a wide variance out in the states on how the profession is regulated in the states. There's a remarkable amount of uniformity out there. So I think more so than other professions, you can trust that your fellow state boards are conducting themselves in a manner that you can feel comfortable allowing practitioners from other states to enter into your jurisdiction to practice. And again, you have regulatory authority over them. So if they aren't conducting themselves in a manner that you feel like lives up to your Practice Act, you can revoke that privilege. You can take any action against that privilege in the same manner that you can take action against the license that you issued. So, I understand the concern, and if the Compact Commission was somehow going to take over regulation in the states for these compact privilege holders, I can see where you'd be very concerned about that. But you're retaining the jurisdictional control of folks inside your state that are practicing. We're not creating a special class of practitioner here that you're going to have to get permission to regulate. I'm in your state with a compact privilege, and I'm engaging in a therapy that isn't allowed in your state. You don't have to contact the Compact Commission or my home state and get permission to investigate me. You can take action against me in the same manner that you take action against someone you issue a license to. Okay, let's see. Let me get over to, okay. And then so really the bottom line is, we're increasing access to care with this compact, like all licensure compacts. We're supporting military spouses. We're facilitating telehealth for practitioners, patients, and clients. We're certain, again, we just talked about this, that OTs and OTAs are meeting acceptable standards of practice. You are seeing these interstate commissions becoming forms for the professions, forms for the state boards that regulate the professions. And then again, with the FBI fingerprint-based criminal background check, the extended reach of boards to deal with folks that might be in remote states, and then the 2-year look back, I think we are offering a higher degree of consumer protection that states can believe in.
So Dan, this might be a good opportunity for a couple of other questions that have been entered into the chat box, and several of these do focus on the FBI background check. Mm-hmm. And so one of the individuals indicates here that the compact is initiated by, let's see here, let me just scroll up here. Let's see here, regarding the background checks, our state does a fingerprint based background check only upon initial licensure at this point, but not with renewal. Does the compact language require background checks with renewals or periodically?
So it will require a background check for someone who is seeking the compact privilege. So it's not tied to renewal. I want a compact privilege. Then we talked about this a lot at the drafting team. The PT compact does it a little bit differently. They just interpreted their language that, and they're doing those FBI fingerprint-based criminal background checks at initial licensure, and so one day every practitioner will have that. But we talked about that extensively at both the drafting team and advisory group level, and left it in place as originally written that you have to get a fingerprint-based background check if you're seeking a compact privilege.
Yeah.
Hey, Dan, I just wanted to add and maybe trigger your memory here. With an FBI criminal background check, there's a new service that's being implemented, the Wrap Back program. So once you have an FBI background check, a state agency can receive updates if there's any type of new action. Now, I don't think that's fully out there, but if somebody gets a background check and they do something bad, it's possible that the FBI would then notify the original requester that something bad has happened. I just wondered if you remember that piece.
Yes. That is a new feature that they're rolling out.
Great.
So Dan and Chuck, here's another question that relates to the FBI background check. This person is saying, what if a licensee holds an existing license in their home state that does not require an FBI background check as part of their initial licensing requirements?
That's fine. But in order for that practitioner to get a compact privilege, they will have to complete that FBI fingerprint-based criminal background check.
Yeah, it's part of it. So here's sort of switching gears here. We've got another question that relates to fees.
Okay.
And so this person is saying or asking, are fees collected by the subsequent states? If the compact grants practice authority, but the practitioner has a disciplinary issue, that states incur the financial cost of an investigation.
Yes, certainly. This compact allows the states, if it's allowed under their law, to seek what's the word I'm looking for here, to seek the cost of that investigation from the practitioner that's being investigated. But yes, that gets back to, you're really going to be sharing the cost with remote states. So if you're investigating, and that's why, the compact states plainly in the adverse action section that remote states have to give the same priority to an investigation in another compact member state that involves one of their practitioners as they do to an investigation that they initiate. So if I'm Ohio and I'm investigating a Kentucky practitioner, Kentucky's going to help me with that investigation because that's what's in the statute. That's what required for membership of the compact. So, my cost, yes, I'm still going to incur a cost for an investigation, but I'm not going to incur the cost alone. I'm going to get assistance from Kentucky that's going to assist me in that investigation. So, it could lead to lesser cost for investigation. I mean, if I had a single state license, in Ohio, but I actually lived in Kentucky, and the Kentucky board decided that, we just don't have the manpower to help you. I mean, that would significantly increase my cost to investigate that. So I think having the fellow state boards as compact member states assist with that should lessen the burden that investigations may impose.
Okay. Chuck, is there anything else you wanted to add about that? Oh, I think you're on mute.
We haven't gotten into this yet, but essentially this gets to a question about how this is financed. And the way the model is envisioned is that when somebody gets a compact privilege, they're going to pay a fee to the Compact Commission to support its operations, but then they're going to pay a fee to the state where they're getting a privilege. And so that would help with funding their operations in terms of doing investigations, but also I think there's some concern that if you get a compact privilege, you're not going to be paying money to the state to get a full license. So the state will get to choose what that Compact Commission fee is that's paid to them.
That's right.
And to that point as well, and Dan, correct me if I'm wrong, but that is very similar to how the compact fee structure is handled with these other professions as well. Is that correct?
PT and once the speech compact is stood up, yes, same. That
Okay.
The states are allowed to charge a fee in order to ease their concerns about revenue loss.
Okay.
The nursing compact will tell you that their state boards have not seen that any impact to their finances because of the nursing compact has been de minimis, and they don't have this compact privilege model. I can get a multi-state license in Kentucky and I can practice in any other member state and they probably don't even know I'm there. So I feel comfortable under this model that we are giving a tremendous amount of relief to state boards, but if it's borne out from what other compacts have experienced, you won't see a huge impact to state board finances.
Okay. So this question here is if an individual had to appear before their home state licensure board for initial licensure due to their prior history, so for example, drug abuse, criminal record, etc., and is ultimately approved for license, how do the other states in the compact know or otherwise have any say in the ability to be licensed?
Well, so here, if we had a lot of talk about this during the advisory group and the drafting team as well, here's where we get back to the trust threshold. If a member state decides to give someone a license, we have to trust that they did that knowing all the facts and made a decision that they can back up. So, if I have a valid license from a compact member state, I can participate in the compact.
Okay.
But because that but that's Chuck. Is there anything you want to say about that? I'm sure there are.
Well, I guess I would add that, they may have a license, but if it's, they're under some sort of supervision or special program,
That's right.
that may limit their ability to get a compact privilege. Now, that's not preventing that person from going directly to another state and applying for a license, but the compact privilege, you can't have any type of encumbrances on your home state license.
Right. Yeah, that's a great point. I mean, if it's such a tough decision to give me a license, odds are they're going to probably put some restrictions around that for a while, and then I'll have to meet those conditions, and then 2 years from the date that I've met those conditions, I can then apply for a compact privilege potentially.
Yeah. And I think, Chuck, the point that you made about an individual being able to apply just as he or she does now, that option always exists, separate and aside from the compact option. You guys, here's another question about the FBI background check. So this individual is indicating, is the FBI background check required for each privilege that an individual is seeking? How is tracking of the states that are joining done and announced?
Let me take the second part first. So you'll be able to track states that have enacted on the otcompact.org website. And then I'm sure NBCOT and ALTA will be communicating through its various channels. CSG will as well, about when states join particular compacts. Yeah, you wouldn't have to get multiple background. You would have to get one background check and be eligible to then get the access to privileges to practice. So once you've gotten that initial background check, if you wanted one privilege or three privileges, that wouldn't matter.
Okay. So here's sort of a follow-up to one of the earlier FBI background check questions. And so this individual is saying or asking, as follow-up to the previous question, does this mean the Interstate Commission will be assuming the responsibility of requiring applicants to obtain the background check if not done as part of the home state requirements?
So the compact requires that as a member state, you have to conduct an FBI fingerprint-based criminal background check on a compact, someone seeking a compact privilege. So I don't think it's correct to say that the commission is requiring that or assuming responsibility. And then the FBI has a very hang up about that information being shared out. So not to get too deep into this, but the way the data system will work for the compact, I mean, you would never report out that I wasn't eligible for a compact or that, I didn't pass my FBI criminal background check or something came back that the specifics about that, you would just tag me in the database as not being eligible for a compact privilege.
Okay. And so with this next question here, the individual is asking, once a compact privilege is obtained, what's the process for a practitioner to keep track of their continuing education units? As of now, it's per state guidelines, certain number of units required per state. Does it depend on the state where the clinician is practicing? How is that determined?
So the way this compact works is the same way that the physical therapy compact works and that the speech pathology and audiology compact will work, is your continuing ed requirements. The only continuing ed requirements that you have to meet are based on your home state license. So I have to track my continuing ed requirements for my home state license. So the states that I get a compact privilege in, I'm not required to comply with those continuing ed requirements unless they're related to scope. So if a state has requirements for me to take some sort of continuing ed in order to be able to supervise or engage in some sort of specific therapy, I'm going to leave it to Chuck and Sean to talk about the PAMs and the DPAMs. Then I would have to complete those. But just as far as, practicing in a state on the compact privilege, I have to keep up with my home state continuing ed requirements.
Okay. Thank you for that clarification, Dan. This question is really about sort of the next phase of this initiative in terms of advocacy at the state level. And this person is asking, are we aware if 10 states will be seeking legislation in 2021? Chuck, do you want to take that?
Sure, I'll take that. And I think we're close to 10. I mean, we've had a lot of conversations with state association leaders and state regulatory boards about who might be interested. And some states have looked at this and said, well, we're interested, but we're going to wait until next year. Other states have looked at this and said, we're ready to go. So, states we've talked to, Georgia, looks like they're ready to go. But I mean, I think they're in addition. Okay, when I say this, I mean, there's like initial interest. There's still some additional conversations that need to be had. With Georgia, I think that the state association's ready, but they want to make sure the licensure board's on board. So Missouri, the state association is looking closely at this. In Nebraska, they're ready to go. And from what I understand, they have a sponsor lined up. In South Carolina, their state association is on board. I think there's going to be a conversation with the regulatory board to make sure everybody's on the same page. I think the same thing is true in South Dakota and Utah. Had a conversation with Virginia. They're very interested. I think they wanted to make sure that their members were ready to go. So I think probably there. Texas, I understand they're going to be looking at moving forward, and I think they have already sent a bill-to-bill drafting. We're having additional conversations. When I say we, AOTA, NBCOT, and CSG, we usually get on the phone with the state leaders, potentially with the boards. We're having additional conversations with West Virginia. Trying to think of if anybody else remembers what other states we have. Wisconsin, we have a call with the state association in early November. So we definitely have interest in at least 10 states. I'm hopeful we'll get more than 10 states introduced in 2021. So we're very excited about this, and we think we have a lot of momentum. And then the last thing I'd like to add is if your state is interested in having a one-on-one conversation with us about the Licensure Compact Initiative in your state, we're happy to set it up. Sean or Dan, do you have anything else to add in terms of states we've talked to? Did I miss anybody?
Well, the one thing I would add is that along with what you're saying, Chuck, in terms of inviting folks in terms of different work initiatives, if there are states that are interested in additional presentations like this, to be able to share this information directly with your state association memberships, that sort of thing, we are more than happy to do that as well. If you just want to reach out with the request in terms of possible dates, times, etc.
Great.
We have one more question here, you guys, and this sort of bounces back to the topic of continuing ed. And so this person is asking, is a home state required to have continuing education requirements?
Yes. Yeah, so if your state doesn't have continuing ed requirements, you would have to implement those before you would be able to join the compact.
Yeah. And we've got another question here that the individual is asking, who is driving the legislation, state associations or state regulatory boards?
I would say in most cases, well, I think it depends. I think in most cases it'll be the state association. There are some states where a state regulatory board or state agency could bring forward legislation. Ideally, the state association, the state regulatory board, they'll be talking to each other along with us. We'd like to see this as a collaborative effort. I don't think we don't want to have any surprises, right? We want to make sure everybody's on the same page. So I think in general, the state association is usually the one with the contract lobbyists. They're getting the bills drafted and working with sponsors, but there are some cases where a state regulatory board could take the lead.
Mm-hmm. And that I would just add there that, that is part of the reason why we're having presentations and meetings, as Chuck indicated earlier on, with state associations. We're also doing presentations with state regulatory boards. It's to, have this conversation to help educate, provide information, and to try to assess interest, on behalf of both parties as to whether or not there is interest and support and the resources available to be able to mount this kind of initiative.
Yes.
One final question, you guys, and I know we are right at the top of the hour, so we want to be respectful of everyone's time. But just one final question in terms of fees. Have fees been set for the practitioner to join the compact? Is there a fee for the states to be a part of the compact? And okay. Chuck, I know you talked a bit about this a little earlier.
Yeah, and in the Q&A, it looks like Angela posted a link. Thank you for doing that, to the PT compact chart, and that's an example of what a fee schedule might look like, where the compact commission, once it's formed, will charge will decide what the fee is to join the compact, and then individual states, the licensure boards in each state will decide what they will charge. So whatever is set up has to be reasonable. If it's too expensive to access the compact, nobody's going to join it. So that's just an example of how one profession has done it. I'll answer this part of the question that the compact does include the authority for the compact commission to levy a fee on individual states, but that hasn't been set or even discussed. And Dan, maybe you could talk about that authority in the legislation and how it has been or not implemented in other compacts.
Yeah, thanks, Chuck. Yeah, that's, ultimately the fees will be determined by the compact commission. for the commission fees. The states can determine the fee for the compact privilege themselves. It's boilerplate language. It's in all the existing licensure compacts that they can assess the states a fee for their operation. Currently, only the nursing compact and the psychology interstate compact are doing that. The nursing compact charges a flat rate to every member state of $6,000 a year. So the psychology interstate compact has a sliding scale. So if, depending on how many folks from your state accesses the compact, that's what I think it's $10 per usage. Again, the compact commission, which is made up of delegates of member state boards, will determine, will answer all those questions.
Very good. Well, thank you so much, Dan and Chuck, for your time and sharing this information with the occupational therapy regulatory community today. And for all of you who have joined us this afternoon, we are really pleased that you took time out of your day and your busy schedules to actually sit in on this session, which really is important for all of us to learn more about. And we greatly appreciate all of the questions that many of you had. This was a great dialogue and really good engagement, and that's what we're striving for here. So thank you ever so much for your participation in the session this afternoon. In closing out, we do want to let all of you know that we do have one more webinar scheduled for next week, and that is November 3rd, whereby we're going to be talking about the NBCOT Navigator and an ethics case, a new ethics case simulation tool, which is or will be a new resource for certificates. And that is will be the final webinar in this series of the virtual version of the State Regulatory Leadership Forum. So if you have other colleagues who perhaps have not joined us for any of the sessions leading up to today, and you would like to invite them, and or if they ask you about it, please know that, as you know, there is no fee to participate, and there is no cap or limit on the number of regulators that can attend the webinar. So for all regulators, whether you be on a board or a board administrator, a board staff, all folks are welcome to participate and attend. In closing, we will be providing the certificates of attendance for all of you who have attended today's session, and you will be receiving that information by the end of the week. So you can be on the lookout for that to come very soon. So with that said, again, thank you ever so much for joining us, and we hope to see you next week for the last session of the Leadership Forum. Take good care, and thank you so much. Bye-bye.